call the February 22nd meeting of the Senate Judiciary Committee to order. Would the esteemed secretary please call the roll?
Thank you, Chair. Vice Chair Cannizzaro.
I understand she's running a few minutes late. If you'll please mark her present when she arrives, and I will make a note of it as well.
Thank you. Senator Orenshaw.
Present.
Senator Harris.
I understand that Senator Harris is on her way. If you please mark her present when she arrives, I will also try to let you know when that is.
Thank you. Senator Settlemyre.
Here.
Senator Hansen.
Here.
Senator Pickard.
Here.
And Chair Scheibel.
Here.
Thank you.
All right, thank you. And we have several members of our staff with us here today. Mr. Guinan, could you please put those on the record?
All right, thanks, Madam Chair. Yeah, this is Patrick Guinan, Committee Policy Analyst, and both I and our legal counsel, Nick Anthony, are present today. Thanks.
Thank you so much. We are going to open today's hearing on SB 95. This is a bill from Senator Orenshaw, and I believe we have Robert Kim, Albert Kovacs, and Mackenzie Warren with us to present the bill. Please go ahead when you're ready.
Thank you, Chair Scheibel. Thank you for hearing Senate Bill 95. Thank you, members of the committee. For the record, my name is James Orenshaw. I represent State Senate District 21. That's parts of Henderson and unincorporated Clark County. And today I'd like to direct the committee's attention to a mock-up that was prepared by the legal division at my request. That mock-up I emailed to all the members, I think within the last hour, and it should be posted on Nellis. So I'd ask Chair Scheibel and members of the committee to refer to proposed amendment 3113, the Senate Bill 95 mock-up that is on Nellis and should be in all the members' inboxes, rather than the original version of the bill. I've been very lucky during the interim to work with the Executive Committee of the State Bar of Nevada Business Law Section, Ms. Warren, Mr. Kim, Mr. Kovacs on this legislation. I believe that this legislation clarifies many points in Nevada law that affects business entities, and I believe that it would be a positive change. The mock-up does represent a lot of discussions with different stakeholders and attempts to address any concerns and reach compromise. With that, Chair Scheibel, with your permission, I'd like to turn this over to Attorney Mackenzie Warren in Las Vegas and Mr. Kim and Mr. Kovacs. And then I'm happy to answer any questions after their presentation, if that's all right with you, Chair.
It is. Thank you so much, Senator Orenshaw. And I would like the Secretary to reflect that Senator Harris has since arrived.
Thank you.
Go ahead, Ms. Warren or Mr. Kim, whoever's beginning.
Thank you, Chair Scheibel, distinguished members of Senate Judiciary, Mackenzie Warren with McDonald Carano on behalf of the Business Law Section of the State Bar. We want to thank Senator Orenshaw for sponsoring this. Especially want to give a shout out to LCB Legal, Mr. Anthony, who worked with us feverishly through the weekend to prepare the mock-up. This is a highly technical area of the law, and we appreciate the LCB's due diligence and legal in helping us get this right. Before I turn it over to Rob Kim to walk us through the mechanics of the bill, a bit about the business law section, and please do save your hard-hitting questions for Mr. Kim and Mr. Kovacs. Senator Orenshaw and I have joked that yes, we remember taking biz orgs in law school, but we don't exactly remember what our score was. So the business law section is a group comprised of practitioners from every corner of the state. They interface with these business statutes and encounter scenarios in their everyday practice that lend itself to these suggested improvements that we're discussing today. These concepts were highly vetted amongst this group, and they were also shared with the other sections of the bar and sought that additional input as well. A quick disclaimer, the proposed revisions within SB 95 have been approved by the Board of Governors of the State Bar of Nevada. Such approval authorizes the Business Law Section Executive Committee to advocate for SB 95 but it does not represent the position of the Board of Governors or the general membership of the State Bar, or of course, the general membership of the business law section. Finally, SB 95 seeks to clarify and supplement primarily NRS chapters 78, 86, and 92A in order to preserve Nevada's status as having the most modern and innovative business entity laws in the nation. These amendments, we believe, provide additional flexibility for Nevada public companies as they navigate the current mostly virtual environment. The bill also adjusts some default provisions of Nevada's LLC statutes to give owners and management additional clarity in the event that the LLC's governing documents are silent, or if the LLC has no operating agreement. While the amendments are mostly technical in nature that we're discussing today, SB 95 does seek to keep Nevada current in our present environment while keeping an eye to the future needs of Nevada business entities. We've had the pleasure of meeting with most of the committee to walk you through the bill. And with that, I will hand it over to Rob Kim to walk us through section by section. Thank you, Chair.
Thank you, Mackenzie. Thank you, Chair Scheibel and members of the Senate Judiciary Committee, and obviously Senator Orenshall for helping us bring this bill to you. As you may recall from past sessions, we try to take input that we have from our own practice, from our colleagues and peers, and through other trends we see with respect to business entities, and try to use them and incorporate them into Nevada's own business statutes so that we provide our citizens and those that avail themselves to our laws the most flexible and powerful statutes that they can choose to if they want to use. So as Mackenzie was saying, a lot of the sections we try to do, this bill in particular tries to clean up a lot of items. There's a prevailing theme. There's a few areas that we'll go into, but I'm happy to just go through section by section, and obviously answer any questions that you might have as well. So I will start with section 1. This is more of a cleanup with respect to service or process for management. As you know, if you do serve as a manager or a representative, officer, director of a Nevada entity, you have agreed to personal jurisdiction in Nevada. And if you do not reside in Nevada, then you are then, I see a hand up, Senator Picker. Did you have a quick question or?
I would ask Mr. Kim that you go ahead with your presentation, and we'll
Okay.
save all the questions for the end. Some of the senators do like to queue up rather early.
No problem. And so this section is meant to change the burden of the actual date of the time frame in 75160, so that's not a burden of the clerk of the court, but on the party seeking service. And that way it's ensured that that will actually happen versus assuming that someone at the clerk of the court will be conducting this as well. So that was the purpose of that, to make sure that that requirement prior to the date running did not get overlooked. As it relates to the next few sections, this impacts sections 2, 3, 7, 8, and 38. If it helps too, I forgot to reference that there was a memorandum that I submitted as part of the materials here that you can track along, where I tried to at least cross-reference the relevant sections as to the different subjects. So the second item does relate to the definition of publicly traded corporation. And in this, what we originally submitted was just to move the definition of publicly traded corporation from some of the anti-takeover statutes that are kind of mid-chapter embedded within chapter 78 and move it forward, because the definition of publicly traded corporation was not limited to those sections. It had been at some point, but with just with the laws developing and publicly traded companies being more commonplace amongst all of us, and what we do, what we operate in, what we invest in, maybe we thought it was appropriate to bring the definition forward to 78010. As you'll see in the amendments, the LCB had thought also to bring forward other sections, but we had thought that it was better to leave those other definitions where they were, because they only did relate to those anti-takeover statutes. We didn't want to bring too many definitions forward that didn't have a general applicability that we wanted the publicly traded corporation definition to have. Also, as part of that, they also cleaned up Securities Exchange Act of 1934 reference, so they brought that forward as well. And there are some minor cleanups that follow along with that. So there's no intention of changing any definitions of any kind, merely just to allow for those users of Chapter 7A to be able to locate the definition of a publicly traded corporation much more easily by having it with all the common definitions. The next section I'd like to reference is Section 4, Federal Forum Selection. So what this section does, it allows a corporation to, in its bylaws, provide for specific courts, federal courts, where they can hear matters relating to that arise under federal law. This is analogous to what we had done last session in 2019, where we had the ability of a corporation in its bylaws to elect to have matters regarding internal actions have venue for those reserved for state courts or other courts. And so the amendments of 78046 focus on the ability of federal causes of action to be filed in federal courts and have the corporation have that discretion to provide that in its bylaws only if it wants to. If it doesn't want to do that, it doesn't have to. And we are offering this amendment because now versus 2 years ago when we had, or previously when we had submitted the state venue forum selection, is because courts now have been a little more decided in terms of allowing these types of provisions. So again, we want to be able to offer corporations, specifically publicly traded corporations, the ability to designate the right venue for the right actions if they feel the need to in their bylaws and articles. Moving to Section 5, in the fiduciary duty section, 78138, we thought it was helpful for practitioners or people that use the section to be able to make very clear that the board of directors is permitted to consider a number of circumstances, contingencies, or constituents, which may include, but is not limited to, the 5 items that we have traditionally stated in our statute. The feedback we had gotten over the years is that people thought that because it's unique to have a multi-constituency type framework, we thought it was, we want to make sure that that was recognized and that people didn't feel the need to be limiting themselves to these 5 factors. And so, because we had fielded many questions to that effect, so we thought it was appropriate to clarify that. The next series of amendments relate to sections 6, 9, and 10, and they relate to the concept of distributions by a corporation. Currently, section 78191 just says that a corporation can make distributions of property to its shareholders for the benefit of its shareholders. And we thought it was appropriate because nowadays with a corporation, they've gotten a lot more complex at times, where they have not just common stock, but also have preferred stock. They also have series of common stock and series of preferred stock, where all those holders of capital stock, they're all shareholders of some kind. And what we tried to do here is make clear that distributions can be made to just members of those different series and classes, and that a distribution doesn't have to be made to every single shareholder, just so that there isn't any ambiguity as to the ability to do so. Obviously, the corporation needs to have the appropriate terms and conditions in its articles of incorporation with respect to any different series and classes, but we thought it was appropriate to update this as well. And along with these revisions, the LCB kind of picked up that phrase and put that also in other sections of the bill. So I think that picked up 78288 and 78300, sections 9 and 10 of the model code. The next area will relate to stockholder meetings, and that covers sections 11, 12, and 14. And so 11, 12, and 14, they cover stockholder meetings, notices generally, and it was appropriate for us to address these, not to really allow virtual meetings to occur, but to just enhance our laws and make sure they're accurately described, as people were now shifting from the traditional physical meetings to more of a virtual meeting, whether entirely virtual or partially virtual and partially in person. And so most of these changes address the fact that some companies may elect to hold virtual meetings only. And so we have instances where, for example, there was a requirement that required a corporation in their notice to state time, date, and place of their stockholders meeting. Obviously, if you opt to have a meeting virtually, there is no longer a place per se. And so we had to just adjust that section to notice that if there was a physical meeting, then you state time, date, and place. If there was a virtual meeting, you just have to say time and date. And so just to make sure that those little details were accommodated for. Now that we are seeing virtual meetings, whether in whole or in part, being more commonplace. The next item is section 13. So this is an interesting area of our corporate statute in that it's entitled voting trusts, but it also covers voting agreements between stockholders. And the provision we're addressing is the fact that the statute had provided for a 15-year maximum on such agreements between stockholders, such voting agreements between stockholders. What we found is that people are actually surprised that there is actually a statutory cap on that, and that you're not allowed to contract around that. So for our purposes, we didn't really change the applicability of the 15-year cap, but we did allow people to contract around it because people may have the the appropriate purposes and reasons to have a term longer than 15 years. But as part of that amendment, we were very sure to obviously make sure that any transferees of those shares of stock have notice of those restrictions before they actually acquire the stock, whether it's a legend or whether it's some other kind of notification. So again, we're just trying to, going forward, allow people to adopt terms longer than 15 years. Section 15 relates to the ability of a corporation to indemnify its directors, officers, and agents. And in this section, we thought it was time for us as a state to include managers as one of those capacities that a director, officer, or agent of the corporation can serve into. For example, a corporation might own many subsidiaries that are LLCs, and then they have one of their officers serve as a manager of that LLC. So the purpose of these amendments is to be sure that that capacity is covered, and obviously to avoid any ambiguity as to what manager might mean. The mock-up does expand on that to say that it is a manager of a limited liability company, and not just any manager as one might commonly interpret that word. Item 16 is a very technical amendment that was asked by us by the real property section to submit. What it does is generally there is a certification requirement under Chapter 81 for certain nonprofit cooperative associations. What we did here is to exempt from that certification requirement certain corporations that are also associations or unit owner associations as defined in Chapter 116.011. That being that usually if you're a member of an association like that, they usually don't have an actual certificate that says you're a member. You're just a member because you own property in the association or in the confines of the association. So that was more of a kind of a trap for the unwary, and the real property section wanted to at least address that and make sure that people weren't required to do things that they weren't doing anyway. Items 17 through 27 address LLCs, and this is probably one of the bigger changes that we're making this in SB 95. And they relate to the default rules with respect to how decisions and voting and other things are submitted or determined by the members of an LLC. And in going through these sections in practice, it came to our attention that there were different ways in which the appropriate threshold was calculated, whether it be a member vote for something, whether it be approval of something submitted to the members. And so, and those varying standards related to extent of one's contributions or the extent of one's interest in profits. And what we thought was more appropriate and was more commonly referenced was to use the contribution standard that is a concept that already exists in Chapter 86. And that would, and the intent there was to say, distributions, decision-making, other things that need either member vote or member assessment would be done based on each member's contributions to the capital of the limited liability corporation. Now, that phrase alone might make someone think that one's contributions to the capital of the corporation would be limited to actual monetary contributions. And to Senator Picker's credit, he picked up on that potential for misinterpretation. And going back to Chapter 86, Chapter 86.321, contributions to capital, an existing section of Chapter 86, makes it very clear that the contributions to capital by a member may be cash, may be property, may be services rendered, or can include a promissory note or other binding obligation to contribute cash. So again, I think it's important because usually when you form a new company, people might have the same contributions, everyone puts in the same amount of money, or it could be a combination of funds, could be a combination of services, could be a combination of relationships, or just other property that's assigned. And I think 86.321 makes sure that all the parties that are contributing capital to the LLC are viewed on par with each other for the value of what they're contributing. So what we're trying to do with these sections that run through sections 17 to 27 is to just have the same default rule with respect to members of an LLC be based on their respective contributions to the capital of the LLC. And of course, notwithstanding the change in default, it is clearly the intent and clearly the purpose of all these default rules in Chapter 86 to be superseded by any agreement between the members. So if there's any operating agreement or LLC agreement between the members, they can adopt their own standard as to any of the matters that might affect the governance of the LLC. So it is definitely nothing we're doing here changes that ability or impedes the parties to adopt their own standards. The next group of sections relate to sections 28 to 31 and 37 relating to dissenters' rights. And here we want to introduce a concept that allows parties that take action that want to approve a business combination that gives rise to dissenters' rights, but want to approve that action via written consent versus an actual formal meeting, the ability to actually obtain advance notice of those stockholders that intend to dissent and intend to demand a fair value for their shares. And the reason why we think it's important to have, and this is a relatively new, I think this would be unique to Nevada in that it allows, this process, this advance notice process would allow the parties to a transaction to be able to assess kind of the obligations or the potential liabilities of that dissenter's rights, of the appraisal demand, and actually build in and have greater deal certainty versus letting it sit and then waiting till the end of the transaction to have an unfortunate surprise that they may have more parties than they thought actually exercising their dissenter's rights and requesting appraisal of their shares. So this will allow for greater information and deal certainty for the parties, and we think it's will be a big benefit for those that use Nevada corporate law. Sections 32 and 35 just relate to defined term cleanup, the use of a domestic corporation and publicly traded corporation. And these are just meant to use this consistent term, domestic corporation, throughout those sections as it relates to dissenters' rights generally. In the sections 33 and 34, much like in Chapter 86, we talked about having a standard based on contributions of capital, we want to make similar changes to Chapter 92A 150 that relates to business combinations involving LLCs to use that same standard. And so in the mock-up, we have references to using an interest standard based on the contributions of capital of the LLC of members as the default voting standard. Along those lines, we also made a similar change in 92A 140 relating to the limited partnerships, so that those entities as well will have the same clarity as to, or same default rule as respect to how voting will be determined amongst limited partners to the extent that already handled in a limited partnership agreement. And then the last item is section 36, where we want to clarify the reference to action for dissenters' rights and make sure that the trigger for dissenters' rights for the notice to be given was the business action itself, and not the action by written consent or in lieu of a meeting taken by the corporation to approve the actual business combination. There was some ambiguity as to when dissenters' notice had to be issued, and some people were using the wrong date. They were using the date of the written consent action versus the date of the actual consummation of the business action. So that was the intent of Chapter 36. So I think I covered most of the items. It does occur to me that there's a new item, section 14.5. Let's see here. That relates to voting. Sorry, I apologize. I just noticed it when I was flipping through this. It is page 22. It's section 14.5 relating to NRS 78630. And there we we've inserted the phrase "at least" before the preceding 10% so that is a minimum threshold of stockholder ownership that is needed in order to be able to bring an action or for a receiver. And that also is consistent with some changes in section 25 and 26 that also try to provide the reference to 10% as a threshold for members of an LLC to bring an action to the district court for receivership or for other actions. And I know those will be items that someone will be speaking as to later as well. So that concludes my formal comments, but I'm happy to answer questions that anyone may have at this time.
And Senator Orenshaw, was there somebody else here to present the bill, or should we move on to questions?
Here, I believe Albert Kovacs had some comments as well. If it's okay with you to go to Mr. Kovacs and then to questions?
That's fine. Go ahead, Mr. Kovacs.
Actually, this is Albert Kovacs. Thanks for the opportunity, Senator, but I have nothing to add in addition to what Mr. Kim just presented, but happy to assist in responding to any questions.
All right, then, if the record will please reflect that Senator Cannizzaro has joined us and that we have concluded the presentation on SB 95, and we are now going to move on to questions on SB 95, starting with Senator Pickard.
And thank you, Chair Scheibel, and thank you, Mr. Kim. You've addressed, in fact, I really want to just put on the record, I appreciate the effort you took to reach out to the committee members, particularly since you spent so much time with me on this. This is an area I practiced in earlier in my career. I've since left that, so you were able to bring me up to speed on some of the more recent changes. But still have a couple of questions, particularly as you and I discussed, in order to get the statute or the legislative intent on the record. First, I'm looking at section, it's 1 I want to make sure we're clear that when we strike the words true and attested copies, we're talking about not requiring the court clerk to provide an attested copy, but we still expect the serving party to provide a true and accurate copy of the document served, so as to avoid any misinterpretation that they don't have to provide because under statutory interpretation, when the legislature strikes a word, knowing that it exists elsewhere in the statutory scheme, that the intent is to delete the word from the requirement. So we're not intending to strike true copies to be provided, correct?
Yes, Robert Kim for the State Bar of Nevada. Yes, that is absolutely correct, Senator.
All right.
I actually went back to my notes, and the reason why true and attested was removed was because no one knew what that exactly meant. But clearly, the intent is to provide true and correct copies, without a doubt, by the serving party to the actual person that is intended to.
All right, thank you. And then in looking at the proposed amendment, most of the definitions were returned to their original place in the statutory scheme, other than the publicly traded corporation. And it's my understanding that that is so that it applies in a broader category of cases and not just within the section that it was placed before. Is that correct?
Yes, that is correct. Just to make sure that it has applicability throughout Chapter 78 and not just within the subset of sections that it was located in before.
All right, thank you for that. And then we changed the definition of stockholder. We dropped stockholder and added 16 or 17 words. I mean, that's taken after my own approach to things, where I like to take more words than necessary to describe it. Were you able to find a rationale for expanding that from stockholders to the holders of shares of one or more classes or series of capital stock of the corporation? Was there a purpose for that lengthy description?
Well, yes. Well, we talked about Robert Kim again for the State Bar of Nevada. So the reason why I thought it was appropriate to amend Section 6 was because we thought there was the potential for someone to claim that distributions have to be made to all shareholders instead of subsets, which the other sections of Chapter 70 clearly allow the corporation to do. To the extent, obviously, like I said before, a corporation has delineated those rights in the Articles of Incorporation, whether through designation or otherwise. So we thought it was more precise that 178, 191 actually just acknowledge that distributions can be made to one or more classes or series of holders of capital stock because of that ability.
Right, and I appreciate that. But as I understand it, then the intent is not to change any underlying stockholder agreements, because all the distributions are going to be set forth in the shareholder agreements. So it's my understanding then that this would not displace any provisions of an existing stockholder agreement in those distributions, but just to clarify the intent, particularly where those operating agreement may be silent as to how that happened, that this is focusing on those where distributions are appropriate. Is that correct?
Yes, Robert Kim again for the State Bar of Nevada. Definitely, we are not changing anything that is already being done and people already expect to do with respect to distributions to different classes and series of stock. That's definitely not what we're intending to do.
Thank you. And then, Madam Chair, with your indulgence, just one last substantive question, and then we can take things offline. When we're looking at sections 18, 22, 25, where we're talking about the definitions, and particularly in 22, I mean, in 18, we don't reference 86.321, but we have it on record. The intent is to include that definition. But the definition that we change in 22 troubles me, and that is where we're taking out the vesting language. And in fact, we're merely talking about majority in interest of managers, or it appears to be that where it's managed by a majority in interest, it doesn't reference non-managing members that would also be vested with an interest or the authority. Can you explain the intent of this section so that we don't do violence to the vesting of interests in non-managing members?
Robert Kim again, State Bar of Nevada. So as it relates to Section 22, 86-291, and looking back at our notes, we had not intended to make amendments to the section, but however, in light of the kind of the global concepts we had introduced, that being the terms in interest and other similar concepts, these revisions were made as well, just to recognize how management would be done on a default rule basis by a majority of the members in interest. And there again, the in interest being a function of everyone's contribution to capital, being then obviously based on cash, property, or the services that each member provides, is how it flows back to a majority of the members with the sufficient voting power are vested with the management of the LLC. Now, I'm happy to speak with LCB as to maybe bringing back the word vested and not, something we had just talked about. And if that's a more comfortable approach, I'm happy to discuss it at a work session to see what makes more sense.
All right, and I appreciate that. Madam Chair, thank you for your indulgence. I just think that this is particularly where we're striking, and this is not changed in the amendment, where we're striking in proportion to their contribution to its capital. So it's almost contradicting what we did before. I think it's really important that we get clear on the fact that we're not intending to change the vesting of authority in members versus managers or anything like that. So thank you for your indulgence. Thank you.
Absolutely. Thank you for your questions, Senator Pickard. Let's go next to Senator Hansen.
Thanks, Madam Chair. Actually, first a comment. Mr. Kim, did you put this memorandum together that you sent with the tables and so forth?
I did, sir.
Just so you know, I've been here 6 sessions. This is probably the best I've ever seen. Seriously, it's great. I went through it and go, man, this guy laid out everything. So just want to thank you. For anybody listening out there, if you want to see a super professional presentation, Mr. Kim did it. So question though, actually, the business law section that you represent, how many people are there? Because I read your little disclaimer at the beginning. You can definitely tell this is put together by lawyers. The business law section is a voluntary section, and you represent the executive committee, but the actual full body hasn't approved this. How many people are on this executive committee that actually drafted this?
Sure. The executive committee of the State Bar, this business law section, consists of anywhere from 10 to 15 persons. There's 13 persons on it right now. And the 13 persons are from firms, small and large, north and south, east, west, whoever has an interest in obviously helping craft our laws and obviously providing input into what it is we're trying to do here, which is providing those that avail themselves to our state's laws, the most freedom and flexibility and foundation that they can have with respect to what they choose to use. Usually what we do is after we usually submit something to the members of the section, just so they know what is being proposed. But once the executive committee meets about 15, 20, 25 times, depending on how often we think we need to put these materials together. And it usually happens in the even year, in the off year, usually from early spring to midsummer. And then by August 1st or so, we were required to submit our proposal to the State Bar of Nevada for distribution to the other section chairs or executive committee chairs.
That answers it times 10 almost. I was just wondering how, I didn't want it to be, Mr. Kim and his wife in the basement coming up with these or something. No offense. So when I hear that there's 10 or 15 and all these different things, that makes me much more comfortable. So anyway,
Sure.
Madam Chair, thank you very much. Mr. Kim, thank you for a fantastic presentation. And I'll rely on Mr. Pickard, since he's practiced in this area, to determine how we vote. I don't normally admit that. Thank you, Madam Chair.
Thank you, sir.
All right, thank you, Senator Hansen. Do we have any other questions from members of the committee? I'm not seeing any, so we will move on to testimony in support of SB 95.
Thank you, Chair. To testify in support on SB 95, please press *9 now to take your place in the queue. Once again, to testify in support on SB 95, please press *9 now to take your place in the queue. Caller with the last 3 digits 124, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair Scheibel. Paul Moradkin with the Vegas Chamber, Moradkhan. The Chamber appreciates the work that has been done by the Business Law Section and the sponsor today, as you've heard during the presentation. We believe this is a cleanup bill that will help us keep competitive with states like Delaware. And we appreciate the intent of the bill, and we do support the bill and the proposed amendments. Thank you very much, Chair.
Thank you, caller. And Chair, at this time, there are no more callers to give support testimony on SB 95.
All right, we will move then to testimony in opposition on SB 95.
Thank you, Chair. To testify in opposition on SB 95, please press *9 now to take your place in the queue. Once again, to testify in opposition on SB 95, please press *9 now to take your place in the queue. Caller with the last 3 digits 522, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Madam Chair, this is Aviva Gordon, AVIVA-GORDON. I'm the managing member of Gordon Law LLC, and I chair the Henderson Chamber of Commerce's Legislative Committee, which represents over 1,800 businesses in Nevada. We have very, very limited at this point, based upon Mr. Kim's, I think, exceptional presentation, very, very limited opposition to SB 95, and appreciate all of the hard work that has been done and the exchange that he had with Senator Pickard. We continue to have concerns over Section 18. In particular, currently NRS 86.091 defines defines an interest as a share of the economic interest in a limited liability company and is not contingent upon contributions. Mr. Kim's reference to NRS 86.321, and I think what is the intention of Section 18, I think needs a little more cleanup to ensure that there is not continued ambiguity with NRS 86.091. Aside from that, the opposition that the Henderson Chamber of Commerce had has been resolved based upon the amendment and Mr. Kim's presentation.
Thank you, caller. And Chair, at this time, there are no more callers to give opposition testimony.
Okay, thank you. We will now move to neutral testimony on SB 95.
Thank you, Chair. To testify in neutral on SB 95, please press *9 now to take your place in the queue. Once again, to testify in neutral on SB 95, please press *9 now to take your place in the queue. Caller with the last 3 digits 101, please slowly state and spell your name for the record. You will have 2 minutes and may begin. Once again, caller with the last 3 digits of 101, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Chair Scheibel and members of the committee. My name is Kim Perondi, Kimperondi, and I serve as the Deputy Secretary of State for Commercial Recordings. Both our Deputy Secretary for Securities and I reviewed and discussed Senate Bill 95 with Senator Orenshaw, Mr. Rob Kim, and Ms. Mackenzie Warren, and determined the changes in this bill apply to the internal governance of business and not the filing requirements within our office. Therefore, we have no concerns, nor do we anticipate any fiscal impact. The Secretary of State's office is neutral on this bill and greatly appreciates Senator Orenshaw and those from the business law section for meeting with us to address our concerns. Thank you very much.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give neutral testimony at this time.
Okay. Thank you, Mr. Kyle, for your help. Thank you, everybody, for your testimony. That now concludes the hearing on SB 95. We will move on to the last item on our agenda, which is public comment.
Thank you, Chair. The phone lines are open and working. However, there are no callers to give public comment at this time.
Okay. I do want to note for the committee that our hearing schedule has changed for tomorrow. We will be hearing SB 113. You should have received the revised agenda earlier today. We'll begin at 1 o'clock as usual. And with that, today's meeting is adjourned.